over your MLAs and cadre means not democratic. I am therefore confident that you and your government has lost the trust of the House and the government is a minority. I'll just pause and look at let us just forget this case for 2 minutes. Look at the consequences of this letter in the constitutional and the juristic sense. Number one, it is a certification by an executive nominee that the departing allegedly disqualified members, allegedly by me, are kosher. They are not disqualified. They are not disqualified is his confidence. Number two, that you, Mr. Uddhav, is not the Shiv Sena, but those people are. He's writing to Uddhav Thackeray. 3, he is doing it under the nose of a pending disqualification, then scheduled proceeding and a hotly contested Supreme Court matter. The ordinary mortals who are doing it, the Lordship take a very serious view. I know the Lordships can't issue directions to the governor, but just consider, if anybody else would write a letter like this, when your Lordship is hearing such a heavily contested matter and the Speaker is dealing with it, I don't know, normally we'd expect some contempt notice. Then some appropriate case will also examine how far the arc of immunity applies. Number 4, he is actually setting up the ground as a precursor. Come to me, I will swear you in. This is an advance intimation. This 7th para read as it is can only say, come to me, I am ready to swear you in. Because you are kosher. There's no problem with you, there's no stigma. Only step left is that nothing is left. Therefore, to the other question, my Lord, the Honorable Chief Justice asked me on Thursday, what is it that you want us to do in the event that we agree with you? Lordship put a question like that. One of the simplest levels, of course, I gave you Lordship a larger answer, simplest levels to quash this letter. Now, suppose your Lordship quashes this letter, just for a minute. And I do not press, except for 1 or 2 things, in any meaningful way for other things. Just suppose, I'm just not conceding anything, I'm just giving the Lordship a supposition. The status quo ante is automatically restored. Lordship doesn't have to say it. And is that constitutional morality? Is that fair play? Is that upholding the greatest traditions of governance? Because clearly it is. And certainly, there can be no bar, immunity, hesitation, legal obstacle, constitutional bar from quashing this letter if your Lordship otherwise agrees with me. This letter is not a non-quashable document,
It's directly impugned.
It's a direct prayer, directly impugned in all the writ petitions or many of the writ petitions. Take it, take it that it's impugned. I don't know if you should take out the prayer. No, not from here. So, now, this is the 4th consequence. The 5th is an obvious consequence of this consequence. Next step is swearing in, which happens on 30th. This is 28th, 30th. In fact, the seeds of that are very clear in para 7. I told you it's an advance intimation. It happens 2 days later. So that's a letter saying you are kosher. That is acting on the letter and giving you a constitutional status of a minister. Well, in fact, I'm sorry, that swearing in was the chief minister. 30th was the swearing of Mr. Shinde.
Chief Minister, correct. 38th.
So you are swearing in a constitutional head of state. And what is the last consequence is again consequential to the consequence, which is appointment of the speaker. If I may say the new speaker or the speaker.
Thank you.
I have given your lordships 6 consequences. I mean, one can make probably 7 or 8 also, but let's say 6. Well, my respectful submission is A, that these are serious consequences, extremely serious for our constitutional polity. B, they are case neutral to the present case. They are extremely serious for our constitutional polity. B, they are case neutral from this present case. They are juristic questions and they are bound to recur unless your lordship plugs the loophole this way or that way. Third, these are all within your lordship's judicial domain. None of this is a no-go area. Fourth, and this is very important, fourth, only your lordship, I'm not saying your lordships may, I'm saying only your lordships can decide and should decide this. I'm not even making an optional rule. According to me, this is only the Honorable Supreme Court which can and should decide it here, not delegated to any other authority. Then, this is the main point, and then of course it follows that your lordship would, as an ancillary, because your lordship passes ancillary. Says, it's just 2 minutes more. Well, your lordship,
I have one question, but I didn't want to disturb your lordship.
I'll just take about 10 minutes more. I'm going to make some. So, your lordship will therefore restore, in the ancillary sense, the position as on 27th or such date. That is, ultimately, your lordship's orders are not spurics. They have to have an effect. That effect has to be only that restoration.
To restore position as on
27th August, June. That is, this is 28th, so 27th is 1 day before. Now, coming back to my note, and I'll be very quick with that's written down. Come to para 12. This is the other facet. Your lordship stopped at 12:13 last time. Just come to para 12 of my note.
Where you are?
convenience clause.
A3, the one your lordship were using.
A3.
Now, what is the point? And I'll be very quick with this. Purposive interpretation in 10th schedule legislature cases, your lordship is repeated many times.
Which page, Dr. Singh?
Para 12 of my note, page 5. This is that A3 note. Oh, I see. It's page 7. Page 7?
It's 7.
In your lordship, it may be page 7.
Yes.
Now, purposive interpretation, what was this new fashion of, now it's old, Bennion calls teleological approach.
Yes. What is it?
It is
Para 12 commences by saying it is further
Respectfully submitted that the above course, the next line is purposive interpretation.
Right.
Or your lordship calls it teleological approach. One of the most abstract books, that Bennion, very difficult to read. Now, let us just see, what is that purposive interpretation? These are the principles. Why does your lordship talk of the evil of political defections? Next para. Now, it will be very brief. Quixote quoted, well known to your lordships. Quixote in para 4 cites the statement of objects. and then says this, I'm reading, the evil of political defection has been a matter of national concern, not combated, likely to undermine the very foundations of our democracy and the principles which sustain it. With this object, an assurance was given in the address by the President to Parliament that the government intended to introduce in the current session of Parliament an anti-defection bill. The bill is meant for outgoing defection. Why are you saying all this in Kyoto, which is 20 years ago, 30 years ago? It's 30 years ago. Because this says that when you interpret anything in this area, you must push this sentiment, this object. That's the object of this. Next, Jagjit Singh. Just see this, fellows. Jagjit Singh, all the citations are given. I'll not go to it. I'll just read it from my notes. The validity of the orders by the Speaker under 2.2 disqualifying certain independent MLAs of Haryana 3 days prior to the election for the Rajya Sabha fell for Rajya Sabha, the MLAs vote was. This Honourable Court rejected an argument that the Speaker's order had been passed in haste, observing that the disqualification proceedings beyond the date of Rajya. Of course, it's an irony. There, you did it to, well, they said we'll prolong the disqualification so he can't vote. I said he can vote in the Rajya Sabha. Here, well, it's the same man as the Chief Minister. If Jagjit Singh is right, well, this is a 10 times a for sure case which we are arguing now. That was only a Rajya Sabha election. Now 29 is what the Supreme Court says. It is also essential to bear in mind the objects, underline the word objects, for enacting the defection law, namely to curb the menace for defection. Despite defection, a member cannot be permitted to get away with it without facing the consequences of such defection only because of mere technicalities. The substance and spirit of law is the guiding factor to decide whether an elected member has joined or not joined a political party after his election. It would not be a validity, etc. I'll skip that. Now see Rajendra Rana, Constitution Bench, well-known case. But it was decided on the basis of purposive interpretation. There were gaps. Your Lordship had to fill the gaps. Your Lordship resorted to purposive interpretation. Kindly see that. This Honourable Court rejected an argument of the initial defection by 13. So this is a two-part defection. Initial was 13. Followed by a subsequent claim by 37 MLAs that there was a split in the BSP in terms of para 3 meant that there was no disqualification of the initial 13 MLAs. Now, this is the good old days of a split existing. Even then, look at the way Your Lordship interpreted it. Your Lordship had the split existing, but see how you interpreted it. By purposive. The court applied the principle of purposive interpretation to hold the disqualification occurs on the date when the acts attracting disqualification are committed. Therefore, the question of disqualification, whether there had been a split, had to be determined with reference to the initial date, not the subsequent date. Thus, the defense to the plea of disqualification cannot be a subsequent defense and must have arisen at the time when the acts constituting the disqualification were committed. Now, just read two marked portions. I will not read the whole one. If Your Lordship permit me, the first 6 lines of 33 only. It may be that the collective dissent is not intended to be stifled by the enactment of 1022. But at the same time, it is clear that the object, mark the word object, is to discourage defection, which has assumed menacing proportions, undermining the very basis of democracy. Well, the very basis of democracy comes close to basic structure. Democracy has been held to be basic structure already, obviously. Therefore, a purposive interpretation in para 2 in juxtaposition of 3 and 4 is called for. Therefore, then one thing is clear, the defection is the ground for disqualifying a member. He incurs the disqualification if he is voluntarily given a membership of his original political party, meaning that the party on whose ticket he got elected. In the case of defense of a whip, I'll skip that to save time. Come to the next marked portion, next para, the highlighted portion. The fact that a decision in this regard may be taken in the case of voluntary giving up by the Speaker at a subsequent point of time cannot and does not postpone the incurring of disqualification by the act of the legislator. Similarly, the fact that the party could condone, could theoretically, there's a para which allows you to condone, the defiance of a whip within 15 days, or that the Speaker takes the decision only thereafter, cannot also pitch the time of disqualification as anything other than the point at which the whip is defied. I'm not only arguing relating back, I'm arguing purposive interpretation, apart from relating back. Relating back is arrived at by adopting purposive interpretation. Therefore, in the background of the object sought to be achieved by the 52nd Amendment and on a true understanding of para 2 with reference to other paras, the position that emerges is that the Speaker has to decide the question of disqualification with reference to the date on which a member voluntarily gives up his membership or defies the whip. That is arrived at by purposive interpretation, no other way. It is really a decision ex post facto. the fact that in terms of para 6, a decision of the question is to be taken by the speaker or the chairman cannot lead to a conclusion that the question has to be determined only with reference to the date of the decision of the speaker. An interpretation of that nature would leave the disqualification to an indeterminate point of time to the whims of the decision-making authority. Same would defeat the very object of enacting the law. Whereas by disabling notice to a speaker, you will achieve the same. By the speaker, the governor writing letters will achieve the same. All these are nullifying the 10th schedule. That's why purposive interpretation is vital. Your Lordship has separately noted with me paras 12, 52 and 53 of Rana. That is done in the earlier department argue. That's not quoted here. Now, Srimant Balaji Patil, Balasaheb Patil, in para 89, which is quoted, just come to the boldface alone to save time. So I'm skipping long paras in between. If we hold that the disqualification proceedings would become infructuous upon tendering resignation. Now, this is another technique, Malas. Because Malas, if you are disqualified, then Malas, you have to fight an election again to become a minister. Well, if you are disqualified, you must fight an election again to become a minister. So people will just resign and then immediately become a minister. Then you get 6 months to be elected. You can become a minister now and need not be elected for a while. So to get around that, this is Malas, your Lordship's purposive interpretation. If we hold that the disqualification proceedings would become infructuous upon tendering resignation, any member who is on the verge of being disqualified would immediately resign and would escape the sanctions provided under 751, 164 and 361. These are remuneration consequences and also most importantly that you have to, you can be a minister but be elected within 6 months after that. That is not available if you are disqualified. Such an interpretation would therefore not only be against the intent behind the introduction of the 10th schedule, but also defeat the spirit of the 91st Amendment. Then, Malas, DTC, an inhibition under the Constitution, this is of course not a defection case, but on the principle of purposive, an inhibition under the Constitution must be interpreted so as to give a wider interpretation to cure the existing evils. Now, this is important, even though it's not highlighted, just read this para, 118. Legislation, both statutory and constitutional, are enacted in truth from experience of evils, but in general language should not therefore be confined to the form that evil had taken. Time works changes, brings into existence new conditions and purposes and new awarenesses of limitations. Therefore, a principle to be valid must be capable of wider application than the mischief which gave it birth. It was born for reason X. Today, our Lordship will expand it to Y, tomorrow to Z, because we learn from experience, brothers. As they said, brothers, not spirit of law, not logic, but experience. Those famous words of Holmes. This is, therefore, a principle to be valid must be given wider application of the mischief it gave it birth. This is particularly true of constitutional constructions. Constitutions are not ephemeral enactments designed to meet passing occasions. These are, to use the words of Chief Justice Marshall, designed to approach immortality as nearly as human institutions can approach it.
Between the two अगर करना है मान लो नहीं और एक सेकंड कह रहे तो है
Yes, Dr. Singh.
The last two lines above para 91 in my note, which is para 16, at the end of, in the application of a constitutional limitation on inhibition, our interpretation cannot be only of what has been, but of what may be. My Lord has got that para?
what is here?
Well, within 16, I have quoted judgments. In the quotation, there is a para 91, 2 lines above 91.
Yes.
Then, Wallace, next 91, I will not read, your Lordship has it, one is coming out of your Lordship's ears, this judgment, 5 days your Lordship heard this. Only one sentence I am emphasizing, which was not relevant for the other case. I mean, I didn't argue it there. This is a quotation, Wallace. Last line of 284. The courts must adopt such an interpretation which glorifies the democratic spirit of the Constitution. I'll skip, Wallace. Whole of 17, I'll skip. 18 is a very important paragraph, but I have in a different way covered it factually. It includes an overlap with the consequences argument. All the facts are itemized there. So I'll skip it to save time. 18. My Lord has seen my 18. You should just keep it as a factual summary. Now come to 20. Allowing the disqualification petition to be decided by a person who has been appointed as speaker with the active support of the respondents and who has conducted himself in a biased and malafide manner would result in incentivizing the constitutional sin of defection. That's the phrase I want to comment for Lordship's consideration. Incentivizing the constitutional sin of defection and would be against the spirit and intent behind the 10th schedule. The same would be in the teeth of constitutional morality. Thus, the principle of purposive interpretation demands that the present speaker not be entrusted. This fellow ends the purposive part. Then para 22 is an interesting point, and not merger. Just see the irony here. Your Lordships has only one defense, fellows, apart from condonation, of merger. Merger is the supreme irony in this case. Merger is not even alleged by them, claimed by them, raised by them. In case of a merger, suppose 8 out of 10, 6 out of 10, 9 out of 10 leave. The remaining chap left behind is protected. Under your Lordship's 10th schedule is protected. Otherwise, he's a loner. He would himself be he's protected. Here, but for Lordship's interim order, which we argued just a few days ago, I'm not protected. Without claiming merger, today they are issuing letters and whips, which I'm not talking about Lordship's protection. The whip is being issued as we speak, in various places, they are entitled to, if the EC has recognized them. But for Lordship's protection, I would be liable to be disqualified for not following his whip. Because without revoking merger, without getting a merger, there is no protection. They become the party. These are consequences. This is a consequence Lordship added in my 6 consequences. This is a very weird consequence. It's a very weird consequence. If you have the defense of a constitution, you are worse off. If you don't take the defense of the constitution, you are better off. I should have mentioned in the consequences list, Lordship will again. And therefore, Malas, I have ended with this. I'm ending my submissions with one Malas judgment which I have to cite. That's an absolute end. Malas. That's an interesting judgment on Malas. Where is it found? Where is it found?
3F.
Compilation of judgments,
3F.
volume
3F.
3F. It's a judgment called Indore Development Authority 2028 SCC 129.
Constitution.
Constitution bench.
On restitution. On restitution.
Yes. Your Lordship is a party to it.
Restitution, no?
Restitution. Because that's the fifth facet or sixth facet of setting right a wrong. Well, you call it actus curiae, your Lordship will not allow your Lordship's acts or judgments to harm a party. Your Lordship calls it a situation created by your Lordship's order, etc. Another facet of saying the same thing is restitution. And my Lord is absolutely right.
Which page you want to read?
This is in this volume 3F at PDF page
1 minute.
33.
1 minute. Starts at
33 is the PDF page of volume 3F. And the citation of Indore development is 2020 8 SCC 129.
33.
33.
Para?
So the first para I wish to read is far away in the beginning. It's para 335 at page.
Oh, 335.
Yes, 335.
At page?
At page
75.
PDF page 275. Mark it now. May I read it, brothers? The page of the PDF is 275.
Yeah.
My lords have got it. The principle of restitution is founded on the ideal of doing complete justice at the end of the litigation. I emphasize the word complete justice and I emphasize the word restitution. And parties have to be placed in the same position but for, I said the but for test, but for the litigation and the interim order. These are very, very important words on the Constitution bench. But for, that's the test. But for the litigation and interim order, if any, passed in the matter. In southeastern coalfields, it was held that no party could take advantage of litigation. It has to disgorge the advantage gained due to delay in case the list is lost. The interim order passed by the court merges into a final decision. The validity of an interim order passed in favor of a party stands reversed in the event of a final order going against the party successful at the interim stage. Section 144 of the CPC is not the fountain source of restitution. It is rather a statutory recognition of the rule of justice, equity, and fair play. The court has inherent jurisdiction to order restitution so as to do complete justice. This is also on the principle that a wrongdoer should not be perpetuated. Sorry, wrong order, not wrongdoers. Wrong order should not be perpetuated by keeping it alive and respecting it. In exercise of such power, the courts have applied the principle of restitution to myriad situations not falling within the terms of 144. What attracts applicability of restitution is not the act of the court being wrongful or mistake. So this is apart from actus curiae or an error committed by the court. The test is whether, on account of an act of the party, persuading the court to pass an order held at the end is not sustainable, resulting in one party gaining an advantage which it would not have otherwise earned, or the other party having suffered an impoverishment. It's very well put. I would commend each word of this. Litigation cannot be permitted to be a productive industry. That is only a fond hope. It is a productive industry. Litigation cannot be reduced to gaming, where there is an element of chance in every case. If the concept of restitution is excluded from application to interim orders, then the litigant would stand to gain by swallowing the benefits yielding out of the interim order. Then they quote, I will not read the quotation. Just pause here for 5 seconds. I get an interim order. The interim order is obviously not confirmed. If the interim order is confirmed, the matter doesn't arise. It is other way around. But every consequence of the interim order is enjoyed, gorged, eaten, and then you twiddle your thumbs and say, tough luck. Now the final order has come too late. You can't ask for restitution. That is what your lordship seek to address by this passage. It's rather well put. For saving of time, I'm not reading. I would request my lords to read Eastern Coalfields from where it draws strength. It's a constitution bench. And Malas, this is the essence of justice. It's the essence of justice. In a constitutional matter with such grave consequences, it is even Malas A for sure. I'm very deeply obliged.
Just one question I had. I mean, it's a facts part. You said, and both Mr. Sibal also said the same thing, that this is not a case where a trust vote is called when the House is constituted for the first time. So that the governor's powers, of course, the governor has the power to call for a trust vote when there is no clear majority on the floor.
But not after the election that you have for the
Right,
first
it's
time.
not after the election because here the government is formed. Very valid point that, this is post-formation of government. What is the power of the governor to call for a trust vote post-formation of the government? What are the circumstances in which he can?
That means a running government.
A running government.
Correct. Well, let me answer on first principle. That of course, we can add some material and give your lordships specifically a note only on this. But well, on first principles, the first answer is that zero, where, because your lordship will decide abstract. Zero, answer to your lordship, direct question, direct answer. Zero power, where there are pending disqualification issues in a running government. Because the lordship should not mix up the two. One is a normal vanilla running government with no issue of disqualification. One is, a disqualification pending at two levels. My candid, clear answer to your lordship's direct question is zero. Number two, the reason is what I have given, Manas. It is a lateral entry of the executive in an area where there cannot be any jurisdiction. There is no locus, Manas, in either 10th schedule or a lordship jurisdiction.
Right.
Number three, if, Manas, your lordship's question is premised, has to be premised and rightly premised on the assumption that the governor, what he does in the question posed by the Honorable Chief Justice, what is he doing, Malas? He is recognizing ABC as the inverted commas majority. There is no relevance to your lordship's query unless the governor does that. Otherwise, your lordship's query would not be relevant. Obviously, it presupposes that he is giving some imparting legitimacy, recognition, or some status. Well, how is that possible?
There's only one gray
In constitutional law, it's not possible.
Not so much from the facts of this case, but we're looking at now from the
Yes.
perspective. On the facts,
I'll tell lordship.
when you read that letter of the 28th of June 2022, the governor, short while ago, you said that what the governor essentially did was to recognize a split by the letter. In fact, that letter does say that so many people have left you, and therefore, that
Without using the word split, is a full recognition, my submission to the lordship.
de facto recognition of a split.
Yes.
Yes. Now, your answer to that is that the governor, so long as the disqualification petitions are pending, he cannot call for a trust vote for the simple reason that you are still a part then of the government which is supported when the House was formed.
Except in one case,
Right.
where, for some freak reason which I cannot think of, it will never happen, that nobody decides to seek to disqualify the other. Now, suppose,
Often the speaker, what he may do is that look,
no,
I don't disqualify you at all.
no, that is not so
Then you
simple.
are- then you contribute to the majority of the.
No, I am doing a juristic answer to your lordship's query. It can never arise in practice, but I am giving a juristic answer. That will have to be a situation where there is no cavil and dispute. I mean, it is virtually by consent of everybody. But with that answer comes the caveat. It goes back to the origin and the object of the 10th schedule. Why was it enacted? It was enacted not to encourage these trust vote situations by defections.
Just come now.
Unless that is so, it will rise every week, every 2 weeks.
One of the last point, maybe we can take 2 minutes to put this to the other side also.
Yes.
It's a worrying issue. There's no clear answer.
No, I'm very grateful because it helps us to clarify in our own minds also. It's just to clarify now.
There is in assessing the strength of a ruling party in the House, whether it's the legislative assembly or the parliament, you have a numerator and you have a denominator. The numerator represents the strength of the party when the House was formed. The denominator represents the total strength of the House. Now, by calling for a trust vote on 28th of June 2022, The governor, according to you, your argument is that the governor therefore recognizes that a part of the numerator has evaporated or has been taken away.
It's rather nice for putting in numerator.
The numerator has been taken away. And therefore now I feel you have lost the confidence in the House. According to you, that is not permissible because the disqualification petitions are still pending.
And he recognizes and gives legitimacy to the numerator. In your lordship example, he is recognizing and giving legitimacy to the numerator.
The only problem which I think, which is kind of not, which is,
Yes.
which is worrying is, does the governor not also recognize that the very act by which the numerator may or may not be affected? All right. For instance, the numerator would be affected even if you don't treat it as a split, and this is a clear disqualification. Then the numerator is reduced by X, the strength of the ruling party in the House, minus Y, the people who have defected from,
Yes.
who have therefore attained disqualification. But equally, that same act affects the denominator also,
Because it reduces the total strength.
the total strength of the House.
Correct?
So, though the governor cannot therefore say, the governor cannot legitimately say that, look, these people have left you, therefore I want to trust.
Correct?
But can the governor not then say that, look, assuming that they have, there is no recognizable concept of a split now under the 10th schedule, the effect of all this is that these people have to be reduced both from the numerator
I
and the
agree.
denominator.
Straight away. There are many answers. First, this exercise cannot be done by the governor because there is no mechanism for it generally.
You have been arguing that he can't assume to himself to take a decision.
First, you have your lordship 3 or 4 answers. Lordship will note down my very specific answer. This is an exercise itself which he cannot embark upon. The governor has no such jurisdiction to embark upon when there is a running house. Now, second
That's
answer.
right. He can't embark. But can you not, therefore, they then say, I want this exercise to be demonstrated on the floor of the House.
No, I'm saying that exercise you can't embark. Let me answer.
Can you not?
Yeah,
That's,
answer.
He has argued that.
Second answer.
Argued that he won't have the. It has to be.
Whereas numerator, denominator, you can't start because your lordship has to premise a direction by me to him. I'm the governor, I'm giving him a direction.
So in other words,
Please have
your
the,
argument.
you can't give a direction.
Got your point. Therefore, to
The legislature, the speaker or the chief minister can say, sorry, I don't know this direction. I don't hear this.
finish your argument, therefore, until the outcome of the disqualification petitions is known to the governor,
Exactly.
he cannot then call for a
Plus 2 or 3. Your lordship will take.
possibly, using your line of argument, we're just trying to understand the
Yes.
argument and stretch it to its conclusion. After the disqualification petitions are decided by the speaker, then there is clarity in the mind of the governor on what is the extent of the numerator which has been affected.
I'm very grateful. I was going to answer, I'm not conceding, but I was going to answer because that question doesn't arise. Your lordship will be very careful about a hypothetical situation, but possibly were. But because why is that? Because a constitutional designated judicial or quasi-judicial tribunal has given a verdict. After that, there is something, as the lordship puts it, that verdict, unless disturbed by the High Court or the Supreme Court, is binding or operating. But here, your lordship's query answers the first part.
There is also
You are doing it well before.
There is another point in your favor, actually, which is that the very same unit which affects the numerator affects the denominator also.
Yes, yes.
Right? So, if the governor cannot postulate until the disqualification petitions have ended that the numerator has been affected, then he cannot say that the denominator is affected.
No, he cannot. By the very arithmetic, it has to be both. It is very selective otherwise.
Right. Because the same act of defection which reduces the strength of the
Absolutely.
ruling party,
Absolutely.
which also then affects the strength of the House.
And Manas, can you start doing this in a this is the word premature stares your lordship in the face. Constitution says this body will decide. This body is ready to decide. You go and give a decision virtually. I will reduce the denominator, I will reduce the numerator. Manas, that will create chaos. And Manas, your lordship has to see Manas
You are saying
Also the-
he can't take cognizance of the existence of the 10th schedule proceedings. He can take only upon an
After-
order passed by,
consequence of the 10th schedule
or
proceeding.
after a determination by the 10th.
That's a very
Determination.
pithy summary. the consequence of the 10th schedule can be some basis, unless disturbed by the High Court or Supreme Court, to act.
Until then, they continue to be members of the.
And it would be in rem. Once that
Otherwise, this would be really a method.
there'll be chaos. There'll be chaos. And unless, not that it should come into your lordship cannot ignore the reality of around the country. Governors also.
We got your.
Governors are no more angels.
Just 2 sentences. Number one, Malad. 10th schedule doesn't recognize majority minority.
Absolutely. No question.
Correct?
Correct.
10th schedule postulates, Malad, that even if there is a split of a majority, it can't be recognized. The governor knows that. The governor knows that, Malad. And Malad, 10th schedule, also, para 3 also said there must be a split in the original political party. 10th schedule, Malad, para 3 said original political. Right.
What's your main
We know that there was no split. Governor knows there was no split in the original political party. So on what basis will he ever recognize? And your answer to your lordship's question, how will the governor call Malad? Supposing one of the parties moves away from the coalition and goes to the governor, along with the BJP, and said, now we are.
That's not an individual act of defection.
Yes, that's right. So this is an individual act. It has to be the act of a party. Now you have recognized the majority as the party and writing a letter to the chief minister. This is unheard of.
So if a party says we don't support the government anymore, that's not a disqualification.
That's
We don't support. If the governor says you've lost one of your constituents. now
Government falls.
Oh, that's fine. That's all right. So that, I'm sorry, but I didn't want to.
Very deeply obliged.
Thank you, Dr.
Thank you, Doctor.
Yes.
Wait, please, Lords. Lords, I'll be very brief, Lords, for 15-20 minutes. Lords, some issues have not been covered.
What are the points that you want?
Yes, Lords, straight away. Lords, I have made a brief written note, but before I come to the note, Lords, I have made a chart of all the prayers for your Lordships. And one or two areas which have not been addressed. If your Lordships have that chart, which has, Lord, the list of 4 writ petitions on this side and 2 writ petitions on that side, it is document 8.
Document A?
Yes, Lord. It's a chart.
Document 8, Lords, consolidated prayers.
Filed yesterday, Lord. It was serial number 1 and 2 are writ petitions filed by my learned friends, Lords, challenging the notice issued by the speaker.
First one.
Yes, Lord. The first 2, but that was the, Lord's subject matter of 27th order. Now, Lords, item number 3 is a writ petition challenging the action of the governor, calling for the trust vote. Lord, that has also been addressed, Lord, at length. That is item number 3. Now, my Lords, serial number 5 at page 5 is a writ petition by us challenging a decision of the speaker on 3rd July 2022 after his election, changing the recognition of the whip from Sunil Prabhu to Mr. Gogavle. But this is a area which has not been addressed, which I will not briefly touch upon. Serial number 6, relates to the actions of the governor, Lords, in administering oath to Shinde, and also, my Lord, that whether your Lordship should decide the disqualification petitions here. And lastly, my Lord, serial number 7 challenges, my Lord, notices of disqualification issued to us. Now, my Lords, I will limit myself, my Lord, to the challenge of 3rd of July 2022. And this challenge, my Lord, is an independent challenge, irrespective of the view which your Lordship will ultimately take as far as disqualification is concerned or governors, my Lord's actions are concerned. Now, kindly have a look at the writ petition itself, my Lord. The writ petition starts.
What is the writ petition number?
Yes, my Lord. That writ petition is 479 of 2022. Yes. Starts at, my Lord, 470 PDF, Common Compilation 1. 406. 406, no? No, it's not 460.
Common compilation.
Plus 6, my lord, I'm sorry, 406. Starts at
406. Common compilation.
Starts at 412. This period. Yes. 406. 406. And if I can just quickly, my lord, point out my prayer there, which is, my lord.
One week.
I'm sorry.
Trying to pull out that. Which common compilation did you say? 3C.
Common compilation 1,
Convenience compilation?
serial number 4. Convenience compilation
It is convenience compilation, not common
compilation. Right.
of documents.
Yes, yes.
Yes. Lords, kindly see my prayer.
Page?
Page, my lord, for PDF, page 408. 408. Lord, this is to quash and set aside the communication of 3rd of July 2022. And the grounds taken are not that the speaker could not have acted on the request of the legislature party. The speaker is obliged only to act on the directions of the political party as far as para 21B is concerned. The decision of the speaker itself.
Would not have acted on the,
Lord Lordship did not take down any notes, it's there in my note.
on the advice of the legislature.
Yes, that's right. I'll just show the documents, Lord, and straight away come to the note. If your lordships have the decision of the speaker, which is of 3rd of July, my lord, at PDF, my lord, 382 CC2 of the same volume of CC, I'm sorry, CC2.
Which one?
My lord, CC2, page 382 of the convenience volume.
Serial number 5.
The running page is 369, PDF page 382. Your lordships are aware, my lord, this decision is taken after the election of the speaker, my lord, on 3rd, on the late night of 3rd. So kindly see what he says, my lord.
Just one second, I'm just trying to track it down. Convenience compilation 2, right? Yeah. Page
Page 382, I'm sorry.
382.
With reference to your above mentioned letter, I have been ordered to inform you that you have been replaced from the post of legislature party by nominating the name of Ajay Chaudhary. In this regard, you have raised the objection by addressing the letter on 22nd June. In this regard, after deliberation on provision in the law, Honorable Speaker, Maharashtra Legislative Assembly has cancelled the approval granted to Ajay Chaudhary as the leader, Shiv Sena Legislature Party, and kindly see the next, my lord, and approves the recognize the nomination of Eknath Shinde as the leader, Shiv Sena Legislature Party. Similarly, the proposal to nominate Sunil Prabhu as the chief of Shiv Sena Legislature Party is to be cancelled and to recognize the nomination of Bharat Gogavle as chief whip of Shiv Sena Legislature Party has been approved and recorded in the registry. So, my lord, my argument is limited to the second part of the decision.
Cancellation.
As far as, my lords, the replacement of Sunil Prabhu by, my lords, Bharat Gogavle by the action of the speaker on the 3rd. And the only material, my lord, which was there before the speaker was that letter of 22nd of June of, my lord, Mr. Shinde, which your lordships have seen, my lord. PDF, my lord, page 67.
It was seen.
Lordships have seen that, which encloses that resolution, my lord, of 21st, appointing, my lord, Sunil Prabhu.
Can you give us a cross reference?
Yes, my lord. That is page 60. No, the earlier. The 67. The letter, my lord, of Mr. Shinde to the Honorable Deputy Speaker is at page 67. If your lordships just have a look at that.
Page 67 at the same compilation?
Yes, my lord. Kindly see, my lord, the heading. It is not by a political party. Shiv Sena Vidhi Mandal Paksh Karyalaya. Clear, my lord, that the letter was addressed by the Shiv Sena Legislature Party at best. And this, my lord, is based on the resolution which was passed in Guwahati. Which is, my lord, that resolution at page 49. 62. At, my lord's PDF page 62. Again, Shiv Sena Vidhimandal Paksh Karyalaya. Sorry, sir. 55. PDF page 55. Again, the heading is also Shiv Sena. Yes, my lord. PDF page 55. Shiv Sena Vidhimandal Paksh Karyalaya. Now, my lord, the defense to this, in the reply, there are only two defenses taken, which your lordship, my lord, have to consider. One is this is an issue which is covered by 212. Court should not get into it. And second, in any event, it is the legislature party which decides the whip. Straight away, my lord, if I can place the reply itself, there are only two issues, my lord, which have been raised in the reply. Kindly turn to, my lord's PDF page 475 of Convenience Volume 1, my lord. If your lordships have page 475,
Sorry, which convenience compilation, please?
Convenience Volume 1. Lords, I have put all this in the note. Your lordships may not be troubled, my lords, to make the
Why don't you take
note
us,
of the pages.
run through that note rather?
Yes, yes, Lord. I'll just point out the pages and
That
straight
will
away.
be,
Yes, sir.
while you read it, you can
I will.
indicate.
Yes, sir. Lords, if your lordships have page 475 PDF, their reply, my lords, to this writ petition. The second column, my lord, from the top, this is the answer to 479. Writ petition is not maintainable in view of 212. And in any event, speaker has no discretion in the matter and has to notify the will of the majority of the legislature party. The lordships have made a note, my lord. Similar, my lords, averments are made at PDF, my lords, 492, paragraph 35, 34, 35, and 36. So, my lord, these are the documents which I wanted to show. Now, straight away, my lords, if your lordships come to my note,
Your notice,
my lords, that is A2, my lords. A2, it's called additional WS.
Devdutt, your A1 is about the 7-judge issue, I think.
Yes, my lord, that's right.
All right. A2.
Lords, at PDF page 2, my lord, the first point, that as far as the validity of this decision is concerned, it's only your lordships, lords, who can take a view on this. And if your lordships kindly see paragraph 8 and 9, this issue on, my lord, whether the whip is to be issued by the political party or legislature party, lords, my senior colleagues have already made lord submissions. I will not repeat it. Paragraph 8, my lords, I've extracted 2B. And 9, my lords, I have given the reference to, my lord, Mr. Sibbal's submission, where not detail Erskine May, etc. Whether it's clear, my lord, that whip has to be issued by the political party and not by, my lords, the legislature party. Now, my lords, coming to the defenses raised in the writ petition, if your lordships have paragraph 12. Paragraph 12, my lords, I have extracted 212. If your lordship sees 212, I'm sorry. It's the paucity of time, my lords, I'm trying to hurry up.
Yes.
Lords, paragraph 12, 212 I have extracted. The first, my lords, criteria for 212 to kick in is that the validity of any proceedings in the legislature of a state shall not be called in question. So my submission is, my lord, that the decision of the speaker of 3rd of July 2022 is not a proceeding in the legislature of the state. And my lords, I am fortified, my lord, by Mohammad Siddiqui's case, which I have extracted in the next paragraph 34, my lord. The above proposition makes it clear that the finality of the decision of the Speaker and the proceedings of the state legislature being important privilege of the state legislature, etc. The proceeding of the legislatures include everything said or done in the House in the transaction of parliamentary business. Now, my lords, deciding a whip or giving recognition to a whip has nothing to do, my lords, with parliamentary business. Therefore, the primary, my lords, ingredient of 212 is not satisfied. Second, my lord, is a more fundamental argument that this is not a mere, my lords, case of procedural irregularity, but a case of substantive illegality and unconstitutionality. Your lordships, my lord, have from time and again said that 212 will not, my lords, help the Speaker's decision to be immune from judicial review if it suffers from substantive illegality or unconstitutionality, even if it is proceedings in the House. Lord, the latest judgment here extracts the Constitution Bench judgment in Raja Rampal. And if I can just place, my lord, paragraph 431 of Raja Rampal, which is extracted at page, my lord, 6, PDF 6. Conclusion, my lord, S, bottom of that page. The proceedings which may be tainted on account of substantive or gross illegality or unconstitutionality are not protected from judicial scrutiny. Then similarly, my lord, U, an ouster clause attaching finality to a determination does not oust the power of judicial review, but not on grounds of lack of jurisdiction or it being nullity for some such reason as gross illegality, irrationality, violation of constitutional mandates. Yes.
Yes.
Now, my lords, as far as, my lord, the decision is concerned, that this is not a procedural irregularity, but a substantive illegality or unconstitutionality is borne by a plain reading, my lords, of paragraph 2 of the 10th schedule. And, my lords, all the authorities and material which has already been relied upon, my lord, that references I have given. If your lordships have paragraph 9, my lord, I have given the references, page 70 to 96. Paragraph 9, page 4 of this note, and I will not, my lords, repeat it. Now, my lord, the second point. Third heading in my note. What is the meaning, my lords, of a political party? Your lordships asked, my lord, during the course of our submissions. What does it mean? Now, my lords, I have tried to explain, because ultimately decisions of a political party, which I will demonstrate, my lord, are ultimately decisions of the political party expressed through its leadership. And when, my lords, 2B talks about directions of the political party, it means decisions of the political party as are communicated, my lords, to the Speaker. Now, my lords, kindly have paragraph 19 of my note. The 10th schedule of the Constitution prescribes a code of prohibited conduct for legislatures within and outside the House. Any commission of the prohibited conduct by a legislature envisages penalty of disqualification. Now, my lord, there are two categories of prohibited conduct which your lordships have seen, my lord. And the footnote will show, my lord, I'm not going to repeat it, what is prohibited conduct for the purpose of para 21A. I've given the references also. Resignation need not be, my lord, explicit. It can be inferred. giving a letter to the governor, my lords, going to the governor with the opposition parties constitute para 218. All the references are there. Now, my lords, the substantive submission on the term political party, if your lordships have paragraph 21 now.
It's not a nebulous concept.
The term political party occurring in the 10th schedule is not a nebulous concept, but a term which has a definite connotation. The term political party referred to in the 10th schedule is an association stroke body of persons which has a definite leadership structure which is recognized by the Election Commission of India under section 29A of the RP Act. A political party is not synonymous with its legislators. A political party includes in its ambit the entire organizational structure which is spread at several levels, block level, taluka, district and state level, apart from the primary members holding those posts. Your lordships have seen, my lord, as far as Shiv Sena was concerned, organizational elections were held in 2018 and the leadership structure was communicated in January of 2018. The documents your lordships have seen, I'm not going to point it out again. But those documents unequivocally show, my lord, who's the leadership of the political party. That is page 1, my lord, of convenience compilation 2. Now, my lords, there is how this concept, my lord, of political party was included. What is the history? I will not trouble your lordships with that. If your lordships straight away have now 29A, which is extracted in para 28. Why this is important is that political party is not something which is anomalous. It is very clear who are the members, what is the leadership structure. So when the 10th schedule says directions of the political party, it means the directions of the political party as is expressed through the political leadership of that party. Paragraph 28, 29A is extracted. If your lordships have PDF page 12, subsection 4 of 29A clearly states that the application shall contain the details of the president, secretary, treasurer, and other office bearers. So the leadership structure has to be intimated to the election commission. Now, my lords, detailed guidelines have been made in the Article 324 under section 29A. And that also, my lord, is a part of this very written submission. If your lordships, my lord, just have PDF page 21, it requires, my lord, the following documents to be submitted, which includes office bearers. The lordships may kindly make a note at page 22, and also, my lord, affidavits to be given by the president and secretary, which is, my lord, PDF page 34. So therefore, my lord, coming back to my note, my lord, paragraph 30. The fact that Shri Uddhav Thackeray is the president of the party, as per the constitution of the party, was intimated to the election commission from time to time. Thus, the terminus of quo for deciding a disqualification petition under the 10th schedule in regard to the prohibited conduct of a legislature has to be with reference to the state of affairs of that political party as it existed on the date of alleged action of disqualification. The term political party in the 10th schedule is referable to the political party as registered and recognized by the ECI under section 29A. Now, my lords, the next section that the 10th schedule is intended to maintain the integrity of the political party, my lord, your lordships have been taken through it. I will not, my lords, trouble your lordships with that. If your lordships now have serial number 5, Roman 5, my lord. Lord, this submission here is. No, Roman 5 at page 15. The correct constitutional conduct for legislators who claim that they represent the original political party is to first get their claim resolved before indulging into prohibited conduct under the 10th schedule. Now, my lords, the core question, my lord, which arises for consideration of your lordships in this case is that when there is an intra-party dispute, can, my lord, certain MLAs take the defense that, look here, I am the political party and I will indulge into prohibited conduct under the 10th schedule. And after indulging into prohibited conduct, toppling government, forming the government, file proceedings on 19th of July before the Election Commission for, my lords, validating that claim. And the defense taken is, look here, I am the political party. So your lordships, my lord, are called upon to decide what is the correct course of conduct in this situation. Para 36, my lord, it is respectfully submitted that in the event of a dispute within the political party, the correct constitutional conduct for legislators who claim that they represent the original political party is to first get their claim resolved before indulging into prohibited conduct under the 10th schedule. It is submitted that if a legislature or a group of legislators have a claim that they represent the original political party, then it is imperative that such a claim has to be resolved or adjudicated upon and decided in accordance with law. Brahmanand Reddy, my lords, was already cited. It is no defense in a disqualification petition to say that the defectors have a claim of constituting the original political party, till such claims of MLAs that they represent the original political party attain fruition by a process known to law. Such MLAs are governed by the code of conduct prescribed by the 10th schedule. Any other interpretation would make the working of the 10th schedule untenable. In the facts of the present case, Sri Eknath Shinde and his faction resorted to prohibited conduct of violating the whip, indulging into anti-party activities, instead of getting their claims adjudicated or resolved in the first instance, and then indulging into political activity. So now the question is whether you undertake political activity contrary to the 10th schedule, indulge into prohibited conduct, or first get your claim resolved. Any other interpretation would lead to 10th schedule being rendered unworkable. This can be demonstrated by a simple example. A legislative assembly has 40 members. Political party A, headed by Mr. X, has 5 MLAs. Party A forms a coalition government with Mr. X as the chief minister. Subsequently, 3 MLAs out of 5 claim that they are the real political party. The said 3 MLAs go to the governor along with the opposition parties to form the government. If the disqualification petitions are filed against those 3 MLAs, the petitions will have to be decided with reference to the state of affairs as it existed on the date of prohibited conduct. You know, this is in line with Rana of relating back. Thus, the faction of 3 MLAs should first get their claim of being the real political party adjudicated and determined, and then take a political decision instead of putting the cart before the horse. This is the only interpretation which harmonizes the provisions of the 10th schedule and the symbols order. This interpretation will harmonize various competing interests and objects and ensure that the integrity of the political party is maintained, and at the same time giving individual MLAs or a group or a faction the opportunity to get the political leadership changed in a manner known to law. My lords, the next submission, my lord, that if the contention of my learned friends is accepted, that moment there is a dispute within a political party, there can't be a disqualification petition, will lead to a complete constitutional hiatus, my lord, as far as 10th schedule is concerned. That, my lord, in paragraph 40, it is respectfully submitted that there cannot be any hiatus in the working of the constitution. It is the contention of the respondent, if the contention of the respondent is accepted, that the 10th schedule proceedings are hinged on a future declaration of their status and or their claim of being the political party, then it would result in a situation where in every case of disqualification, a defense would be taken that the defectors represent the political party and therefore no action of disqualification can be taken. Taking the argument to its logical conclusion, it would only mean that till such claim of the defection defecting faction that they represent the political party is decided by a competent forum, the 10th scheduled proceedings cannot be proceeded with. This would result in a constitutional hiatus. Lord, then I have cited Supreme Court of Canada, my lord, that on constitutional interpretation, and also, my lord, your lordship's judgment in the Advocates on Record Association. Then, my lords, serial number 7. Lords, I respectfully submit that ultimately, my lord, your lordships will have to lay down the batting order, as my lord Justice Narasimha put it. Lords, that is paragraph serial number 7. It is imperative for this honorable court to lay down a constitutional sequence in order to harmonize the 10th schedule 179C as well as para 15. As is evident from the facts of the present case, the respondent MLAs, instead of first resolving their claim in a manner known to law, have resorted to prohibited conduct. The proceedings before the Election Commission were initiated only on 19 July, that is much after the disqualification petitions were filed on 23rd June 2022. Then paragraph 44 is the Lord's submission. Thus, it is imperative that this honorable court lays down the constitutional sequence and the legal permissibility of 3 distinct constitutional stroke statutory procedures, namely 1, proceeding of disqualification under the 10th schedule, that is 2nd is 179C, my lord, which has already been argued, and then, my lords, paragraph 15 of the symbols order. It is respectful submission of the petitioners that the 10th schedule proceedings necessarily have a constitutional precedence over 2 and 3 above. Second, my lords, para 15 proceedings, which are based on the majority test, cannot be undertaken and proceeded with without final adjudication of the 10th schedule. And third is the nabam rebia, my lord's argument. Then last 2 submissions, my lord, are on the symbols order. And, my lords, I have submitted that the reason is, my lord, that decision to the defense.
That's not an issue which falls here.
Yes, my lord. One of the questions which was referred to your lordships, my lord, in the reference order relates to the power of the Election Commission. But the only defense which is taken, my lord.
It's a separate.
Yes, my lord. The reason is, my lord, the defense which is going to come, the lordships will probably hear, is that, look here, we have now been adjudicated as the party. So therefore, the disqualification petition are anyway not maintainable because it is, my lords, given by a person who is not the political party. So, my lord, just 2 submissions on that. If your lordships have paragraph 47, my lord, I have submitted that as far as para 15 is concerned, it cannot be undertaken, my lord, without determination of the 10th schedule, which your lordships will examine other matter. And last, my lords, paragraph 49 and 50 is that the decision of the Election Commission, my lord, is a declaration of status, that who is the political party pursuant to a split which has arisen. That can only have a prospective, my lord's, effect. It can't relate back. Kindly have, my lord's, paragraph 49. It is submitted that under paragraph 15 of the symbols order. Yes. It is submitted that a decision under paragraph 15 of the symbols order is a decision which can only have a prospective effect. Then, my lords, I have quoted paragraph 15 of the symbols order. It's a quasi-judicial, my lords, adjudication under the symbols order. That, my lord, adjudication of the dispute results in an order declaring, my lord, XYZ as representing the political party. And this submission is, my lord, that can only have a prospective effect. Now, my lords, kindly see the consequence. If it is held otherwise, that it relates back, it would have, my lord, in our respectful submission, complete, my lord, disastrous consequences as far as the 10th schedule is concerned. Because when the decision comes, for instance, in this case, it has come in February, my lord. Petition moved in on 19th of July. And today to say that in view of this decision now, in February 2023, all the actions of prohibited conduct get effaced, my lord, would be to destroy the complete intent, letter and spirit, my lord, of the 10th schedule. Lords, all the other submissions and judgments are there.
Thank you, Mr.
I'm grateful for a very patient waiting. Grateful.
We'll start after lunch, but just before we rise, Mr. Paul will first argue, thereafter Mr. Jetulani and then Mr. Manandan. Roughly, Mr. Paul, how will you space out your submissions? How long would you take? You'll take the rest of the day today?
My lord, the Solicitor General would of course also appear.
I, my lord,
The governor.
So,
My
Mr.
lord,
Paul,
I would definitely take today,
right,
whatever time, and tomorrow, my lords.
day and tomorrow is Wednesday.
Yes, my lords.
Entire.
Yes, my lords, I have 3.5 days of arguments or 4 days of
All
arguments.
right. So we want to wrap up the matter by the end of this week.
Right.
So, what we would suggest is that, you can begin, of course, you will take the whole of the day today. If you can sort of complete, say, 1 hour after lunch tomorrow, say by 3 o'clock, that would ensure that then Mr. Jetulani and Mr. Maninder Singh can conclude, say, by tomorrow evening. And then the solicitor can get a little time day after, and then the rejoinder.
So I'll try my best.
Okay.
There are-
Mr. All right, let's do it this way. Mr. Sibal, between you and Mr. Dr. Singhvi, how long would you anticipate for a rejoinder? I mean, that.
Well, if it's 2 o'clock in the afternoon on Thursday, we'll finish by 4.
So if you
Between
can.
us, we finish by 2
on
o'clock.
Thursday, I may not take more than 1 hour, 1.5 hour, my lord, maximum.
All right.
We'll endeavor to finish by 2 o'clock on Thursday.
That's right, that's fine.
So then, what we were suggesting was, if you can, between the three of you, you can finish by tomorrow, ideally. Then, the solicitor says he'll take about 1 hour or 1.5 hours on Thursday. So if he begins at 11, by 12:30, he'd be done.
Then
We still have a little bit of a half an hour margin, He said 1.5 hours. So, we just.
Try our best, my lords, is all I can say. It's not true.
Between the three of you and the solicitor, if you can finish complete by Thursday, 2 p.m. Then they have the rejoinder after lunch on Thursday.
that's enough for us.
Then, so maybe the three of you and just Mr. Solicitor can also have a word, so that, you space your arguments and, what you're going to argue, so that
Your
is
lordship,
the
is
time.
sitting, your lordship is sitting at 3:15 for a bail matter, we're told. So
3:50, 50.
we'll only be sitting in the bench till
3:50.
3:50.
We thought because 3:15, then we'll really eat into your time.
Yes.
We might continue beyond 4 o'clock, but we'll.
Obliged.
Very
Right.
close.
Right, your lordship.